what I can do for him. Here's the problem. I placed him on probation on July 23, 25 under 771.1. I can't go longer than a year. He hasn't paid his fines. Your name again?
That's what I'm.
What else didn't he do?
He didn't clear all of his warrants. He did have quite a few warrants. He did clear all of them but one. We're down to one.
I don't know. I gave you a year. You didn't, I told you to get those done by September 15 of 25, not that you'd want to listen.
And then
This is now July the 22nd, right? 22nd? You're late. You got to get us. Go ahead. I don't know what I can do for him. I can't do anything.
Judge, he had a lot of.
I know, but what can I do? It's a year. I mean, I can't go past the year.
He did do the best he could. He got it down to one, warrant inside of
Can he
red.
pay the 270 now?
He can pay it this week, Judge.
He's gonna have to pay it today because this is the last day prosecutor's here, and prosecutor can move to dismiss. But the year expires tomorrow. Go get the money. Can you get the money? You got a credit card or debit card? I don't know what to tell you. I mean, you don't follow orders.
You can have the 270.
Wait a minute. I can't, the prosecutor's not going to be here. I need a motion from the prosecutor to dismiss this. I don't know what to tell you. You've dragged your feet the whole time. I told you to come and talk to me if you didn't have the money. Did you do that? No. Because that's too inconvenient. Even though I offered to do it by Zoom, I don't want to argue with you. It's just now you want me to bend over and do something I'm not supposed to do. Because I have to have a motion from the prosecutor to dismiss your case. I'm willing to overlook the clearing of the warrant if you've only truly got one left. And if you can pay the 270 now, I don't have a problem with saying to him, we're okay to dismiss him. But I can't, he's not here tomorrow. They're only in here once a week typically. Some of them are only in here every 2 weeks. What do you want to do? Can you go to somebody and call them and have them pay this?
No, I get my check from work tonight. I was gonna pay it in the morning.
And he can,
Colin, Mr. Urich, I'll tell you what, this now becomes everybody else's problem because you don't listen. But I'm gonna go out of my way, because if I was as fair as you are right now, or have been with us, I'd take your plea, enter the conviction, and resent you.
Judge, if I could, he was always communicating with me about his lack of payments, things like that. But you always ask that they have to talk to you before their due date.
I know.
Always past that at that point, so I thought it was gonna be works for him to talk to you.
I know. So then they don't want to do that because that's inconvenience. It's gonna take them 10 or 15 minutes to wait only on Zoom. We're gonna, Mr. Urich, you got a hold of John?
I got a hold of him, coming in.
If he can come in with it in the morning. And he's done everything else. You just, Mr. Urich, come on in here. Your name?
Pointing her out, I mean, the city wouldn't.
Defendant here has been dragging his feet and he still owes, wait, I'm trying to help you here. What are you talking to your lawyer for?
That's if I pay it in the morning.
I asked him.
He can pay it in the morning, right?
Yes.
So would you write up his step? He failed to clear all warrants, but he only has one month. How much does he owe? Does he still owe 270? Is there other fees added in there, Heather?
No, it's still 270, Judge.
You bring in $240 tomorrow morning. Prosecutor will consider writing up if defendant pays $240 by Thursday, July the 23rd, prosecutor moves to dismiss and is willing to disregard the fact that he didn't comply with clearing all warrants, something like that. Okay? He only has one left. I'm willing to overlook it. If you don't show up tomorrow, though, there's nothing I can do. All right? What, you want to come in here at what time?
Probably gonna be off at 6, so can I do 10:30 again?
We'll give you 10:30. We're here to please. We try to help. We're trying to make sure everybody is, the only ones that are inconvenienced is the court. We want to make sure everybody can do these now on golf courses, boats, and their patios, and their summer homes, and You come on in at 10, if that's what you want, we'll give you that. And then I'll worry about the rest. We'll write that up, put it in the file. Thank you. Come on in tomorrow. She'll give you a notice. Good luck.
Thank you, Judge.
And then you gotta still set your case with Judge Hessen though. So Heather, you're gonna have to set his case on a probation violation with Judge Hessen,
I think maybe that's fine. You can always look to throw in the.
or whatever that is.
Oh.
Yeah, this is me.
It's not a probation, it's a contempt hearing for failure to pay. So you're gonna have to have that hearing set tomorrow too, okay? Or set today. So
Oh.
you'll set that today in front of her, Heather?
Okay, is he gonna go in there today or set it for tomorrow?
No, just give him a date so he can regroup and get his money together, okay?
Okay,
Thank you.
Thank you, Judge.
Alex Richard Sobelak. Where's Mr. Sobelak? 25W840. Mr. Patillo, would you tell Mr. Crawford to come in here, please?
Yeah.
This is 25W840 292 OM. People against Alex Dobelak. Alex Dobelak. Your name, sir?
Alex Richard Sobolek?
Sobelak, I'm sorry.
That's okay.
Looked like a D on the paper that they wrote.
Yeah, Sobolek.
I have to wait for your lawyer.
I understand.
No, I like one.
Crawford, your appearance?
Michael Crawford, representing.
Mr. Sobolak is here. He's going to plead to attempted larceny. They're going to dismiss the original charge. He's serving 12 months on a probation violation. If you plead to this charge, the possible penalties are up to 250 fines, 45 days jail, costs, or all those. Do you understand that?
I do.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, right to bring in your own. The right to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all those rights, and we are not going to have a hearing or a trial. Do you understand that?
I understand.
To the third charge, attempted larceny, how do you plead?
Guilty, Your Honor.
On November 12 of 25 at 10:30 in the morning, we at 22051 West Road at the BP gas station in Woodhaven.
Yes.
What did you do?
I voluntarily hopped in a vehicle that somebody had stolen.
Did you attempt to steal that vehicle from somebody?
I did.
What, did somebody leave the keys in and go inside the station and you just decided to get in and drive away?
I didn't. I don't want this to come off as misleading. I did not physically get in the driver's seat. Somebody else did, but I did get in the vehicle after it was started and stolen.
Did you know the person who was in the vehicle?
I did know the person. Yes,
And you
sir.
were getting in to help him somehow or her somehow steal the vehicle? Is that true or false?
It's true.
Are you on probation or parole?
I'm on probation, Your Honor.
You understand by pleading guilty here, if you were on probation on November 12 of 25, this would be deemed a violation of that probation. That probation could be revoked. You could be incarcerated on that charge as a result of this plea and conviction. You understand that?
I do, Your Honor.
You still wish to plead guilty?
Yes, sir.
Anybody force you to plead guilty?
No, sir.
Please accept it to attempt larceny, the regular larceny dismissed. I don't understand why they're charging all these felonies as misdemeanors over there. I've never seen anything like it.
My client is fortunate and realized this.
He's been in custody for how long?
I believe he's been in custody.
June 9th.
How long, sir?
I believe June 9th. Yeah, June 9th.
Yes, Your Honor. He's currently looking at 12 months, Your Honor.
Judge Gillis ordered him into custody for 12 months.
Yeah.
Is that true?
Yes, Your Honor.
Can you verify that, Heather?
I was sentenced on the 17th of June.
So you got some time to spend here, eh?
Yes, Your Honor. I understand what I've done and I'm here serving my time.
Your Honor, once the court verifies that he is indeed serving 12 months, we're asking you to serve jail time and ask it to run concurrent.
What's that first one? What? Oh. That is
I'm gonna make it easy. 250 fines, 200 costs, 75 victims' rights, $50 justice assessment, $575 or 60 days concurrent with sentence imposed by Judge Gillis. Well, I hope you get your life together. How old are you? You're 23?
No, I just turned 33 on the 13th. Yes, Your
Well, I
Honor.
hope you get your life together. Good luck. Thank you.
Thank you. Thank you.
People live yet? Henry, Destiny's son, Henry. Destiny Daniel, 26W842-495.
Morning, Your Honor, I'd like to cooperate.
Do I have the victim out there by chance? Your name, ma'am?
No one on
Read-
Zoom, Judge.
Did you read this victim's rights statement with your lawyer?
I didn't get out to see.
It's right here. I'll let you read it with him. How's that?
Thank you.
You read that with her, and then I'm gonna recall it, okay? Ramel Labertus Howard Jr., 25W388526. Is this yours?
Yes, Your Honor.
Come on up here, Mr. Howard.
Michael Call representing Mr. Howard. Who's our PC.
Male versus Howard.
He was in front of me on June the 18th of 26. He pled guilty to failure to complete community service and failure to pay fines and costs. I think I told him to make sure he'd done all that by the time he came back. Today is the, I set a review hearing date for, well, I set the review hearing date for September 16th, but today's the date scheduled for sentence.
Sure.
Anything you'd like to say on his behalf? Did he tell me he did things?
My client is happy to report that he has indeed completed community service and provided documentation to the probation department. And he would have made the payment on his fine, driver. However, the payment system appears to be down. But probation has verified that it's down and he has some numbers prepared to tender it.
Call in Jessica, will you please?
And let me be clear, he's prepared to tender at least $150, Your Honor.
But he owes
He owes a little bit,
$545.
but the hope is because it's.
Where does he
great
work at?
progress. He works there.
I work with, I just had the last time that I talked to you, I was telling you that I had a new job, so I was just still in training, but next week I'm fully.
She's turning everything on, sky's the limit.
Your name?
Just so how much
He did the community service.
community service is done, the work proof is provided.
How painful has he been throughout this process?
He's been good. He's been, again, I think we're finally getting on track here. I think we're finally doing what we need to do, realizing how serious this is. He's always good with communicating with me, letting know what's going on. He was gonna make a payment today. Unfortunately, the eSport system's down, our online system. He does have money to put about $140, I believe, today.
150.
150 today. And he will still be on probation with us and reviews not until September 30th.
Pay $150 today. I'm just gonna set a date for you to pay the balance. I'm gonna give you until August the 31st. So you have to wait to pay the $150 today. I'm not gonna impose any community service additional or extra costs. I'm gonna do that for you. I'm glad you got your community service done. Stay with it. If August 31 comes, if you don't have the money, call the court. We'll go on Zoom. I'll be more than happy to give you an extension, okay? Just don't ignore me, please, all right?
Thank you.
Thank you, Everett. People against William Cullen Everett, 26W843-625A and B. Good morning.
Morning, Judge. Deanna Patillo, 8237A, on behalf of Mr. Everett, extension.
How you doing, Mr. Everett?
Good morning. Good morning.
All right. Does he stand in wait formal reading?
Yes, Your Honor.
$500 personal bond. I'll give you some time. You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. I'll enter an not guilty plea. Are we doing August 20th when Ms. Patillo's here again? Is that, oh no, I can't, can I? Okay.
Yeah, this will be, we could do August 19th at 9:15.
But it won't be with Ms. Patillo.
No, unfortunately.
Okay,
I switched, those ones. I think it's Thursdays.
at 9:15 it is then, okay?
Yeah.
Any questions? So you're gonna go take care of your tickets? I'm entering the plea of denial on the no proof. Have a great day. Do I have more with you, Ms. Patillo?
Not yet.
Okay.
Yeah, this young man would like to speak to his attorney.
May I, Your Honor?
Yeah, what's your name again?
My name is Arnie Leiter, but I got a cute story for you.
Come on up here. Wait a minute. Are you with, Ralph?
No. I'm a solo practitioner.
Come on up here. Go off the record.
Solo practitioner since my mentor, Albert Hatchett, passed away.
Okay, nice to have.
But I got to tell you a cute story, which you like. I've been doing this for 52 years now. 1974, I just left the prosecutor's office in Oakland County, and for some reason, got a case out here in New Haven. Never been this further south in my life. Drove for an hour and a half, it came out here and was in front of your dad. And we talked, he was gracious and treated me well. And I know the conversation was there was a judge out in Clarkston for like 30 years.
Gerald Lee.
Nally, who came to my wedding. We were close and I asked if we were in a relation. They said no. So we concluded that matter. 1995 or 96, I had a second case out here and it said Judge McDowell. I thought, oh my gosh. So I remember coming out and said, Judge, you don't look like you aged at all. And then he said, I am.
Well, my father's been deceased since 86.
So,
Yeah. But
that's the story. And I'm just hearing from Judge Henson. I'm not.
that's great. It's good you're still
I need to tell
practicing.
you that.
It's good you're still practicing.
Yeah, I turned 82
Good for you.
and I'm gonna keep going. Why not?
Why not? What else you gonna do?
Nothing. You sit here, people, first year they retire, they die.
I know.
Or have a stroke, you know that.
Exactly.
The kids
Well,
don't.
you look great.
Thank you. I'll tell you, 2 years ago when I was in the court, called the kids, young boy said, Mr. Weiner, why don't you retire? You're 80, go sit on the beach and relax. So it turned out about weeks later, we had planned to go down Florida, Cancun. So I said, I'm gonna do just like that commercial, right? I'm gonna take, that Corona commercial.
Right.
I'm gonna take my chair, which I did. I put it on the sand and to the right of me.
Mr. Ross, I know you had a lawyer. Where are you?
No lawyer. Yeah.
You didn't have a lawyer. Come on up.
Talking.
Cameron Joseph Ross. This is 26W843-633. I also have 26W843-649 A, B, and C. And I also have 26W843-824 and 260-10732. Well, you gotta stop getting so many tickets. Your name?
Cameron Ross.
I'm gonna adjourn these. First of all, you have a charge of no trailer plate from July 1 of 26 on Tiffany near Pinecone. That is a misdemeanor, punishable by up to 100 fines, 90 days jail, costs of all those. Do you understand that?
Yes.
You have 2 civil infraction charges. CMB, motor vehicle parking prohibited, and you have another one, prohibited parking, and then you have another one, prohibited parking, another one, failure to change address, and another one, parking loader trailer. That's the one I arraigned you on. Loader truck with a trailer attached. I'm gonna enter not guilty pleas on all of these. I'm gonna give you a new court date. We're doing July the 29th. When's Judge Hudson's docket there, Heather?
July 29th for Woodhaven for her.
At 8:30 or 9:30, or what do you want?
We could do 9:30.
At 9:30 in the morning, okay? 9:30 in the
Are we
morning.
keeping ours under us and then her, Judge Hassan with hers?
You do whatever you want. You're the boss. I'll do whatever you want. Okay?
All right.
Judge Hudson, that's next time.
Do you want it in front of Judge Hudson?
It doesn't matter.
Set it in front of me at 8:30, all of those, okay? I'll take all those cases. Thank you. Go down the hall, we'll give you your new notice, all right? Set them at 8:30, Heather. Thank you. CNC Contracting LLC. T6W 43425. A and B. Who's this now? Who's got this case?
What did the prosecutor recommend?
Well, I don't know what he means. Did he write anything up or I can't?
Can we call him?
Yeah, where's the defendant in? I need to know where the defendant is.
Yes, sir.
Is anybody here for CNC Contracting LLC?
Oh, that was me.
You have those too?
Yeah.
Jeez. Come on up here. 6343425B, name. I hope you're gonna comply with laws better.
I think once we get into the specifics.
Oh, I mean, if you're telling me they either are picking on you big time, picking on you, like to the point where it's over the top picking on you,
Yeah.
which any kind of picking on you is bad. You got 10 citations here.
Yeah.
Your name?
William Young, I have to say,
I'm adjourning this one too.
I'm sorry, Judge?
We're adjourning these trailer plate and fair to change address.
Affirmative, Your Honor. We discussed this matter with, one of the two citing officers as well as Chief Rust. So the effort is obviously well intended to try to get some full compliance. In essence, it's at least the people's position right now that the defendant is running a full-blown commercial business.
You and I are not gonna get along well if you're gonna do that. Listen to me very carefully. Usually when these people come in here, I'm just telling you, I'm not saying you're one of them. You might be the one in 10,000 that doesn't. But when I get this feeling that people are coming in here and telling me the police are picking on them, there's usually a reason. And the reason is because people are not complying. Now I'm gonna expect you to get this under compliance. Do you understand?
Hopefully, I understand. I have no problem.
If they're just going out there, they're gonna hear a mouthful from me. If they're just out there bugging people. I don't believe that. I mean, you got 10 tickets here. Are they wrong on all 10 of these? They're civil infractions. Heather, give them another date on these contracting cases too.
I'll just do the same date, Judge.
All right, you do whatever you gotta do down there, okay?
Okay.
Kind of messed up this file a little bit. Go down and get your notice, all right? Good luck. I'll be ready on Destiny Henry. Destiny Danier Henry, 267842495.
Michael Crawford comes in this name. Thank you for recalling the case, Your Honor. We've had the opportunity to review the victim statement and prepare to proceed.
Your name, ma'am? Is everything in the report accurate?
Yes, Your Honor.
Anything you'd like to say on her behalf?
Your Honor, my client understands that she made some bad decisions in this particular case. I think the court is aware that the underlying issues here are really a family law matter. This family has taking certain actions, such that my client hasn't been able to see her child in at least 7 months. She's understandably upset, but she reacted poorly. It has been, she understands she can't do that in the future. Talk with her about that. She takes up these issues in family court, which has begun, Your Honor, it's pending. So you won't see this type of behavior out of my client again, because again, it's really focused, try to get the proper custody for her child back as soon as she can.
Anything you'd like to say?
No.
You are going to stop contacting them. Now, I'm gonna let you in on a secret. If you don't believe me, you can write it down and put it in the blackboard of your mind. I can't, judges, they wanna hamstring this with a lot of things. But one of the things they can hamstring this with is violation of a no contact. If you violate that, if you've done everything else right, I still can give you the max. And I want you to understand, if you violate the no contact provision, you and I are going to have a big problem. You don't have the right to threaten people, to bug people, to text people all the time. 18 months probation, you cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation after a report is directed. No contact with Michelle Newsom except in conjunction with circuit court proceedings. No firearms. You're not to possess firearms. You're not to possess dangerous weapons. No firearms, no dangerous weapons. You're to continue mental health treatment weekly, and you're to take all meds as prescribed by physicians and mental health specialists. You're to serve 5 days on the court work program. There's a $35 a day charge for that, for a total of $175. You're to serve 2 days of community service, 16 hours by September 10. Pay fines, $200, costs $100, 75 victims' rights fee. $50 justice assessment. So fines and costs are $4.25. Probation fees are $360 for $785. Screening fees $60 for $845, and then you have court work program fees of $175. The total is $1,020. If you violate, your probation could be revoked. They only charge you under a local ordinance, which is a 90-day misdemeanor. And they did ask me to take this under HIDA. I mean, they were awful generous with you. I'm not gonna speak for them, but give me a review hearing date, Heather, in 18 months. So we should be looking at the end of 27 would be good.
Okay, let me get my 27 calendar here. We could do December 29th.
I'm going to.
December 29th to 27 at 8:30 in the morning. Can she pay all of this today?
Not all of it today, Your Honor. My client is taking it seriously. She can pay $800 today.
Good.
If the court would give her 30 days, she'll pay.
I'll let her pay the rest by August the 31st. How's that? If you don't have the money, you call the court, we'll go on Zoom. I'll give you an extension, okay? Thank you very much. Have a good day. What do you have?
Miss De Palma, Judge.
Is that an easy one? She didn't show up. I should kiss your name.
Eric Kish.
The charge is fair to refrain from consuming alcohol, testing positive for alcohol on a chemical test from DNA on July 13 and 26. How's he going to proceed?
Your Honor, my client would plan to take responsibility. There's an explanation you'd like to share.
Plead guilty here, you could get 10 days. This would be a second violation. No, actually, you've had 3 priors. You could get every probation revoked, and you could be incarcerated for the maximum, which on this would be 93 days. Do you understand that?
Yes, sir.
You're presumed innocent. They have to prove you guilty by preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena power of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right, any questions before we go on to that charge? Fair to refrain from consuming alcohol, testing positive through DNA on July 13 of 26. How do you plead with that?
Guilty.
Did you test positive at DNA on July 13 of 26?
Yes.
Did you consume alcohol, say within the 3 days preceding that?
Yeah.
Anybody force you to plead guilty?
No.
I'll accept that plea. I find it to be an accurate plea made voluntarily and understandingly, so that this is the summons via probation violation of July the 20th. I'm accepting your plea here today to fair to refrain from consuming alcohol. Your name is Wells?
Elizabeth lost probation.
All right, so what do you have to say here, counsel?
Well, Your Honor, from what I understand, this is really an accident. He went out for a golf trip on the weekend. He went out there with all intents and prepared to act responsibly. He brought several non-alcoholic beers with him so he could stay distinct from his buddies. And the only way he can explain his possible exposure, that he grabbed one of the wrong beers and handled one of the wrong beers.
Oh my gosh, you guys, they're not even getting, how do I say, unique anymore. Look me in the eye.
Yeah, can I say something?
No? Did you intentionally consume alcohol on that day?
Not intentionally, I did.
Then let's have
I
a,
did have a beer.
Yep.
One. I had 3 non-alcoholic beers in day.
slow down. I'm not taking your plea, you didn't intentionally consume alcohol. If you didn't intentionally consume alcohol, I'm gonna swear her to an oath. I'm going to swear you under oath, if you choose to testify. And we will go from there. You want to confer with your lawyer before you answer that question?
Yeah.
Go ahead, talk to him.
My client would like to maintain his guilty pleas and disgusting.
Did you intentionally consume alcohol?
Yes.
Why did you just tell me you didn't intentionally consume alcohol? Wait a minute. Before you answer that question, you have not learned the single most important principle of a sobriety. And that's honesty. I don't want people in the sobriety court that aren't honest. I get the fact they're gonna relapse, but I don't want them in here if they're gonna look me in the eye and tell me something that isn't true, and I know not to be true. I mean, this is not, I don't understand how it is that anybody who comes in here and is concocting stories would think they're gonna get one over on me. I don't take it personally that they think they are. How old are you again?
34.
All right, well, I've been doing my profession for 43 years and a judge until the time you were about 2. So, and I'm talking about being a judge. So that means I've heard every story from A to Z. Every story, every lie that there is to hear. I don't want you in sobriety court if you're not going to be honest with me. I never liked you working at this bar to begin with. You got no business putting yourself in a position where you're going out on golf outings. I know what happens on golf outings. And now you come in here and you lie to me. Now, wait a second. Why you stop?
Well, Your Honor,
He said he intentionally consumed alcohol. If he didn't intentionally consume alcohol, we're having a hearing right now, and I'm going to determine whether or not he intentionally consumed alcohol.
Your Honor, I think it's true. I think my client would admit that it's true that he knowingly took alcohol. But in terms of the use of the word intentional, I think upon reflection, what he was trying to communicate, to the court, that when he came to this golf outing, he didn't come with the intent of hanging out, having a drink with his boys.
But he did anyway.
But he came with the intention. That's why he brought the non-alcoholic. He was thinking he could toe the line. And this was one of those times when he failed. He relapsed. he put himself in a bad situation.
So what I would have expected is that he come in here and tell me that. Anybody force you to plead guilty here,
No,
please accept it. I don't know what to do with it. You tell me what I should do with it.
I honestly, Judge, I don't know. I mean, we just went through this a few short months ago in regards to, of course, his prior violations. Him claiming the non-alcoholic, beverage, finally kind of came to truth. I was hoping he learned his lesson about being truthful at that point, especially since he served a little bit of jail time. But we're in a position now where we're kind of far enough in the program that it has to be considered if he is appropriate to continue. I think Mr. Kish, as I think I've said before, it does have a serious problem with alcohol. The environment he's in, like you mentioned, is just not a good environment to put himself in the predicament of the tournament. He knows he can't possess frequent, and that's exactly what you're doing when you get on a golf cart or you go to a golf tournament and there's beer in the basket. Maybe he should have left. That would have been the better choice. So I'll leave it up to the discretion of the
What
court.
about the restricted license? Where are we with that?
We took that away from
Right.
him
Right,
because he attempted to drive with.
right, right. And they go,
Well, Your Honor, but I understand that it appears to me that the actual prior violations was for him failing to provide a sample. In other words, shy bladder syndrome, and I believe he supplied some type of documentation to the court, if not, he can. And that's why he was really violated. I can't speak to some of the other comments here. Pardon me. So I would just hope the court can kind of emphasize on exactly what it has been found guilty of. It's failure to test after attempting to several times. It's clearly documented. He attempted 3 times.
I think I dismissed
Mr.
those.
Crawford's looking at a very previous violation.
I think I dismissed that.
Yeah, he's violated for consuming alcohol, attempting blowing.
I did take a plea on one for failure to submit. I took a plea on one for failure to pay fines and costs. And I took a plea on the last one for testing positive, at least on the interlock. So I'll grant you this. He's really had 2 violations for drinking. And he had the one for failure to pay, which I'm not as concerned about, to be honest with you. And then the other one for failure to submit. But I remember we went through that shy bladder issue.
Thank you, Your Honor. Bottom line is my client is asking the court give him this one final chance. He believes this private court is good for him, wants to continue on. I find it difficult how the court might resolve, or ask my client to resolve, the issue about his employment. It's my understanding is that he owns the facility. So,
I get it.
I mean, he has to somehow interact there to properly exercise his ownership.
Where is he phase-wise?
Your Honor, I didn't bring my face sheet in. Eric might have a better answer for that. I know we had
Tell me where
extended
you
up,
are.
but I believe we put him.
I know, but how far through 2?
It was about a month ago, but then it got really tornado siren.
Yeah.
And then it closed down. That was when I was supposed to phase up, and then actually she gave me the paperwork last week. So
Here's what I'm doing. What do we have him now? Testing twice weekly?
Yeah, he is in the full benefits of phase 2.
We don't have him a sober link, right? Or do?
Not anymore.
I'm going back on the sober link. You're going back on the sober link at your expense. And you're to pay for your own testing. Until September the 20th. So I want him back on a sober link by the end of the day. I want him paying for his own testing. I want him paying for his own sober link until September 20th, and you're to serve 3 days jail. So you're to report to jail. I don't know how we can work that out because we're going to be closed probably when I want him back on a sober link. And I don't want to make a condition on him getting the sober link because they might not get him out if they send him to Detroit. So,
Then upon release on, assuming he goes into custody now, if he's released late Friday or early Saturday, as far as Wednesday, Thursday, Friday, he can go directly to house arrest
you're to
services.
obtain the sober link within 12 hours of the time of your release. Do you understand that?
Yeah.
It should have been a lot worse. I'm gonna give you a last chance. You gotta take this more seriously and you gotta be more honest with me.
Yes, sir.
I wish you well. Good luck. Not assessing costs. He's paying enough of the penalty. That's K4M Towing Inc.
Thank you.
26W843337. Good morning, counsel. Your appearance? Hi, Mr. Batty, I need in here, and Mr. Matty. Mr. Matty, your name?
Yes, I'm here.
Your name?
Carlo Matti.
And where's your lawyer at? Mr. Batty, I need your name.
Carlo Matti.
I know. I need your lawyer, though.
Good. I apologize, Judge. Good morning, sir. Danny Batty appearing on behalf of Mr. Matty, P84624, Judge.
I need you to start your video.
Oh, there we are, Judge.
All right, Mr. You're not driving, right?
No, Judge, I am actually just got to my destination. I'm pulling over right now for 2 seconds. I could have. Here I am, Judge. There it is. I know better than to drive in your courtroom, sir.
Well, it's not my courtroom, but you shouldn't be driving no matter where you are. I can't
Absolutely.
believe any judge would take anybody driving while
No,
they're
we
handling the
definitely-
case. I would hope that they're not. If they are.
Absolutely.
All right, your appearance, you're over now, right?
Yes, sir. Good morning to you, Judge. Danny Batty appearing on behalf of Mr. Matty, P84624, Your Honor.
Your name, sir? Again, Mr. Matty?
Yes.
All right. Counsel, he stands mute ways from a reading, right?
That's correct,
Yeah.
Judge.
You're now authorized under this plea where he's going to plead to expired plate, civil infraction, and they're going to dismiss the misdemeanor for commercial vehicle, right?
That's correct,
Yes.
Judge.
To that charge of expired plate, responsible or not responsible?
Responsible, Your Honor.
I'll accept the plea, 185. Can he pay that today or does he need time?
I will get it paid today, Judge. If we could just have till Friday so I can get it situated
I'll
with
give
him.
it till July 24th, okay?
Thank
Good
you, Your
luck.
Honor.
Glad we took care of this. Thank you very much. Have a good day. Thank you.
You too,
Thank
Judge.
you. Thank
People
you.
against Brown, Amy Diane Brown, 25B149845. A and B and 25T 645-864. A and B, your name?
Brown?
I set this for a sentence. Did you talk to your lawyer yet?
Yes, I have.
Who's your lawyer today?
The gentleman, the lawyer that was just up here, can't remember his name.
Have a seat right behind you, okay? I need to wait for him. My mistake. Dingus. Brandon David Dingus, 24W87783. Your name?
My name is Brandon Dingus.
This is an improper storage case. And they're reducing it to a violation of the civil nuisance ordinance 1-106. Is that what you want to do, is plead to that?
Yes,
To that charge, responsible or not responsible?
possible.
All right, what happened here?
There was a camera stored in my house that, was moved.
All right, he's recommending fines and costs of $250, or it says no more than $250. Let me check this. All right, you still live on Cambridge?
I do.
So why did you take so long to remove it?
It was during a divorce.
All right, 225, you're all set. Cash, you're under the hall to your right, okay?
Thanks, sir.
Best of luck. If you want to find your lawyer, Ms. Brown, I'll call you next. People against Daniels. Daniels, did you have a lawyer, ma'am?
Yeah.
Hang on 1 second. Brush, did William Brush have a lawyer?
I don't think that was going up today.
William Brush, come on up here. William Matthew Brush. 25W838383. What's going on there, Mr. Brush?
How you doing, McNally?
Not too bad. Where, is there a Matthew Bielik here?
No.
Look, you been in any trouble? Have you been in any trouble?
Negative.
Well, you took some time to answer.
I'm sorry, I didn't hear you.
That's okay. Was this taken under an ordinance section, Heather? I don't think it was. He's just making a petition for early discharge, right?
I'm sorry, Judge, who is this one on? Is this on Brush?
Yeah, William Matthew Brush.
I believe this one might be a motion for early discharge.
You just did this on your own, right? You filed the petition on your own?
No, I talked to Jessica last month.
Well, I get it, but you filed the motion for early discharge, right?
I mean, I didn't really file anything really.
I got it.
If she wants to let me off early.
Well, I'm gonna let you off. You're all set. You've done everything. You're entitled to it. You're released from discharge. You're released from probation. Best of luck to you. Thank you. Thank you. Lateral Morrow?
Yes, sir.
26W843-636. Did you have a lawyer? Yeah, I just can't call these cases. If you can grab her, I'll get you out of here.
Shoot.
Yeah, I know. Cameron Joseph Ross.
Yes.
Did you have a lawyer?
I do not.
26W843-633. Your name?
Cameron Joseph Rowe.
You have a truck trailer, parked on the street. Oh, with attached trailer and boat. No trailer plate on the boat was a warning. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
No, Your Honor.
That's the charge. You understand what you're charged with? Having a truck, with an attached trailer and boat?
Yes, Your Honor.
And that allegedly occurred on Pinecone near Tiffany and Woodhaven, July 6th to 26th at 9:20 in the morning. That is a misdemeanor punishable by up to 100 fines, 90 days jail, costs are all those. Do you understand that?
Yes, Your
And
Honor.
did you sign, read, and understand the advice of rights?
Yes,
If you plead guilty, you'll be giving up all those rights, and we are not going to have a trial. Do you understand that?
Yes, Your Honor.
All right. I'll enter in that. You want to waive your right to a lawyer still?
Yes.
Not guilty, please enter. $100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court if elected. We're going to get that over to the prosecutor. The Woodhaven City Attorney will call you out. If he doesn't call you out the next 10 minutes, come on back in here and tell us, okay? So he's going to take that to the prosecutor right now. You understand everything?
Yes, quick question for you. During that time frame, they issued 6 tickets.
Talk to him about that.
Okay.
Talk to him. You got issued 6 different tickets.
6.
Did you pay them all?
No, I'd like to try all or talk to you about all.
Well, why in the world didn't you respond to the other ones? Did you respond to the other tickets?
Yeah, I responded to them. Yeah. They're set for later. I mean, it's been within the last few weeks, not just the both multiple vehicles. It's an ongoing thing that I'd like to talk to you about.
Well, you're gonna, we got a process though. I just arraigned you. You couldn't go explain to the prosecutor. If he doesn't like what you're talking about, you still want a lawyer. If you can't afford one, I'll give you one. If you can't afford one, I just arraigned you, you're gonna have to go hire your own. Okay? But I can't just have a conversation with you.
Basically what I was asking, the clerk said it's up to you if you want to pull all the tickets together into one case, because they're set with, Judge Husson for some of them and you for others. I didn't know if that's possible or not.
Yeah, I can do that. I'll do that. Has he been arraigned on the other ones, Heather?
That is correct. He did take a $3.
Let me take a look. This was on, let's make sure I get the right person here. What was his last name again, Judge? I'm sorry. Was this for Ross?
Yes.
All right. Let me take a look.
Let's worry about that later. You go talk to him about this one case. How's that?
I have all the tickets.
Okay, good enough. Good enough.
Yeah, because he has quite a few. Are we just real quick, Judge? I want to know, are we looking at all of his that are open? Because he has quite a few.
How many's quite a few?
Oh. So there's, he has 1, 2, 3, 4 parking, failed to change address, no trailer plates. So 1, 2, 3, 4, 5, 6 total charges are open. But they're all Woodhaven cases.
Has he been arraigned on the criminal ones and or
let's
talked to?
see. No on that one. No on Judge Hessen's. So yeah, no, he has not been arraigned on either misdemeanor. Obviously,
Go
he's being
talk to
arraigned
the
on yours right now.
prosecutor and tell the prosecutor your situation. I don't mind taking them all. If he wants to pull them up all now and talk to this gentleman, I don't have any problem with that, okay? So you can tell him what your predicament is, okay? Ms. Patillo, which one again?
I have Alexis Daniels.
Let's do that one real quick. And Brown, then you have, right, counsel?
Correct.
Alexis Chantenay Daniels, 260-648-393B. I also have 26W-842-9848 and B.
Dion Patillo, be 8378 on behalf of Ms. Daniels. Oh, that's Ms. Daniels.
All right, so what are we doing? We have a driving on a suspended from May the 28th of 26. Does she stand mute and wait for my reading?
Yes, Your Honor, we would be requesting an adjournment just for clearances, Judge.
Lady, why haven't you been showing up on this? You don't endear yourself to judges when you do that. Do you understand? Yeah. Got a ticket in April, one in May. You didn't show up. You play this again. I get it. It's easy not to show up. You're gonna end up in jail with me. Do we understand one another? Do we understand one another?
Yes, I do understand.
$500 personal bond on 393B. That will also cover 84A. Still, I'll give you a $500 personal bond. Actually, I'm gonna give you a $500 personal bond on that one as well. We are going to give you a new date. And the new date in these cases will be when, Heather?
Do we want to give her 2 or 4 for
4
clearances?
weeks is good.
We could do August 19th at 9:15.
August 19th at 9:15, but you're gonna have to fill out a petition for a court-appointed lawyer if you want one. Do you work, ma'am?
Yes, I do.
Where do you work at?
Outside this rehab,
I can't hear you.
outside this health and
How
rehab,
much you make there?
30 an hour.
Oh, you working full-time?
No, part-time.
How many hours?
It's 36 hours in a pay period.
Boy, that's good money.
You know, not really, I still got 2 kids and.
No, I'm not saying I didn't say you're rich. I don't know what it takes to be rich anymore. That's what I'm doing, August 19th. You fill out a petition for a court-appointed lawyer. Good luck.
Judge, her one case is a Trenton case, so we do need to, I had a different date
Give her
on
the
that
new
one.
dates. Ma'am, I just gave you
Okay.
misinformation. One of these
Well,
is a
what-
Trenton case.
Yeah, one of the dates is okay, the date that we gave her, but she had a warrant on another one, so that was a different date. But I can extend that out if you want us just to give it that at the window, because I gave.
Give it to her at the window. Make sure you
Okay,
show
not a
up.
problem.
Okay? All right. Do you have Brown, counsel? Amy Diane Brown. 25B 149-845A and B and 25T 645-864 A and B.
Morning, Madam Mayor, Golf, election news, Garden Stance.
What are we doing with Ms. Brown? This has been going on since I was a kid practically.
Your Honor, my client was ordered,
What? Well, I don't want to embellish. That was kind of embellishing. These are only 25 cases, but it wasn't exactly a kid. Ms. Brown, what are you doing? You gonna pay these? What's going on?
Your Honor, the last hearing, you ordered that she paid $400 before she comes here, I was gonna throw her in jail, but my client complied completely. She's actually paid more
To who?
but $450 to the court. I saw some documentation.
Did she pay $400?
Over $400. I found documentation.
Tell me on what cases, Heather.
Well,
All right, let me take a look. She has
Paid
a
200,
few.
it looks like, on July the 13th and 200 on July the 6th. on 25T645864B. I said I was gonna throw her in
Yep.
jail?
Well, we were hoping it was her early.
Or he told me to show up, and then I showed up, and then he told me if I didn't.
Where do you work at? Where do you work?
Sure.
Do you live?
Hey, my page.
Do you work?
Yes, sir, I do work.
Where?
I'm the hairstylist at our salon in Belleville. So I plan on paying 200 every 2 weeks to get
Yes.
paid off.
Did I sentence? I didn't sentence her yes on the one, on the tribe drive while suspended, did I?
Not yet.
Well, let's do that today.
Judge, I do see a $200 payment that was made on July 13th on case ending in
Made on the
864B. Yep. And then I do see one on July 6th also. Yes.
This is what I'm gonna do. 25B149845B, how much she owe?
We believe it's $180 to the yard.
How much she owe on 864A?
864A is 230.
Do you have $250 with you?
I can pay it today, yes.
You pay $125 now on both cases and I'll waive the balance. That's too nice, I know.
Thank you.
So that's on 864A and 845B. Okay, so you're still gonna pay the rest on the one file, 85864B. That's the one you paid $400 on, 200 on July 6th, 200 on July 13th. And I'm simply adjourning the sentence. Actually, I'll go ahead and set you on the suspend. Anything, counsel?
Nothing, Your Honor, except my, she learned a lesson. She's went through a bad period in her life, made a series of unfortunate decisions. She's paying for those now. She's battling some health issues that she's looking forward to being victorious through. You won't see her again for this, Your Honor. She's committed to getting things paid. She's got a plan. So she just hopes for a little leniency because she has unlimited budget.
Taking care of my mom and dad, so I don't have a lot of expenses, so most of the money that I make, I can pay for it normally. It's my main priority is being the courtroom.
Oh, gosh, you should run for Congress. The way you said that, that's my main priority. Leave the court. 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 325 or 60 days. I'll let you pay $50 per week on that. And I won't start that one until August the 24th. And if you need more time, you come and talk to me. I'll be glad to give you an extension, okay? And honor before the due date though, okay? If you don't have the money, no problem, just come talk to me. Best of luck. Malat, Bradley Jacob Malat, 25W8388481. Come on up here, Mr. Malat. What's the pretrial again in name?
Franklin Mountain.
I cannot dismiss this. You have another retail fraud. And I placed you on probation on June the 25th. So here's what I'm doing. Do you want a lawyer?
No.
I mean, I can't do anything when you got another retail fraud conviction pending or charge pending. Conviction entered. Here's what I'm going to do. Conviction entered. We're going to set this for sentencing. We'll give you 5 weeks. If defendant not convicted of a misdemeanor, I'll change my mind on this, but it looks like you got this other retail fraud. Court will likely change mind, I'll write down. I can't take it for more than a year. But Heather, give me a date about August the 25th, 6th. With Woodhaven. Can you hear me, Heather?
I'm sorry, I was talking to you and I was muted. We don't have Woodhaven here that last week because that would be Judge Hessens and she's off. We have them here August 19th or September 2nd.
August 19th at we'll make it at 9:15, okay? Go down the hall, get your notice. That's gonna be down for sentencing. If you're acquitted on that other case altogether, then I'll set aside the conviction. But right now, we're ending the conviction for failure to appear, failure to
I'm sorry.
comply, rather.
What
Good
time
luck.
did you say, Judge?
9:15.
Okay.
Thanks. Good luck. Go down the hall, get your notice. William Cullen Everett, 267-843-625 A and B. What other one do you have, Mr. Teal?
Judge, I have Latero Morrow, and he's on break from work, and,
I don't know where that is. Where's that file at?
yeah, and then I have Robert.
Oh, I'll get that next. Your name, sir?
William Everett.
You're charged with driver license not valid and the civil infraction and no proof of insurance. You have the right to an attorney. Would you like one?
Yes, ma'am.
Okay, we'll set you up with a lawyer. You go out in the hallway, you'll meet with the lawyer. I think this is gonna be, just go out there, we'll set you up with a defense lawyer. Go right out the hallway, all to those pews out there. Thank you. People Against the Child Moral, 26W843-636.
Good morning, Judge. The advocacy of the 8237, you don't have Mr. Mine.
He waives formal reading, stands mute.
Yes.
Latero Morrow.
All right, not guilty, pleas earned, $1,000 personal bond. You cannot leave the state, cannot violate a law. You must appear in court as directed. Should I give him with Ms. Patillo August the 19th?
Let's see. That, yes, we could do that.
Where do you work at?
Work for Market Seabury. So, a nursing home.
How much do you make?
So,
If you can afford your own lawyer, great. Otherwise, you're gonna have to fill out a petition for one, okay?
And I'm sorry, Judge, Miss Patillo's not here on the 19th. It was the 20th that she was going to be here.
Oh, I can't do the
Which-
19th?
Yeah. No, she won't be here the 19th.
That's all right. We'll set her up. We'll set him up with another lawyer who we have.
Okay.
Okay? Go down the hall. You're gonna have to fill out a petition for a court-appointed lawyer if you want a lawyer going forward, okay?
Thank you, Judge.
Am I making sense? Look at me. Am I making sense?
I don't understand.
I'm adjourning your case. I'm giving you a new date. You're entitled to an attorney at the first hearing. If you were Warren Buffett, I'd have to give you a lawyer at the first hearing. After that, I have to make sure that you're indigent. Personal bond. You don't have to post any money. Look at me. Look at me. Don't talk to your lawyer. You don't have to post any money. You'll owe $1,000 to that city of Woodhaven if you don't show up in court, or you leave the state without consent, or you violate a law. Do you understand that?
Yes, but can I say something?
Depends what you want to say. I got all these people here. Go ahead. What do you want to say? It's just an arraignment today.
My kids, I have a vacation set up with my kids, so.
Okay, when?
It was July 30th to August 4th.
Where are you going?
We're supposed to go to Tennessee.
Good. You can leave the state to go to Tennessee.
Yes, sir.
You can go to Tennessee. I'll just say until August the 5th. That'll cover it, right?
Yes, sir.
All right, you're all set.
Thank you.
Good
Thank
luck.
you, Judge.
Go down, get your notice. Make sure you fill out a petition. Robert Lewis Thornton Jr., 25-837-260.
Imagine standing before a judge after being given chance after chance, only to hear that your time has finally run out. That's exactly what happened in this courtroom, as a defendant returned hoping for leniency, but instead faced a judge who made it clear that court orders are meant to be followed, not ignored. The hearing centered on Robert Thornton Jr., a defendant who had previously been placed on probation and ordered to complete several conditions before returning to court. According to the judge, Thornton had been given an entire year to resolve outstanding warrants and pay the fines required by the court. Yet when his case was called, those obligations still weren't complete. As the hearing began, court staff explained that Thornton had managed to clear most of his outstanding warrants, but one still remained. Even more importantly, he had not finished paying the money he owed the court. The judge immediately expressed frustration, reminding Thornton that the deadline had already passed and that the court simply couldn't extend the probation period any further because the law limited how long the case could remain open. Thornton's attorney tried to persuade the judge to show mercy. The attorney argued that his client had made significant progress by clearing nearly all of the warrants and was prepared to pay the remaining balance. But the judge wasn't convinced. Instead, the judge emphasized that the problem wasn't simply the unpaid money. It was the failure to follow clear instructions over the course of an entire year. The judge reminded Thornton that he had repeatedly been told to contact the court before the deadline if he needed additional time. The court had even offered to handle those conversations through Zoom, making it easier for him to request an extension. Yet, according to the judge, Thornton never reached out. Now, on the very last day, he was asking the court to bend rules that the judge said could no longer be changed. As the conversation continued, the judge became even more direct. He told Thornton that the situation had become everyone else's problem because Thornton had waited until the final moment instead of taking responsibility earlier. Even so, the judge stopped short of immediately entering a conviction, explaining that he was still trying to find a fair solution despite the defendant's repeated delays. Thornton explained that he expected to receive his paycheck. Imagine already serving time for violating probation, only to walk into another courtroom where one guilty plea could make your legal troubles even worse. That's exactly what happened during this hearing, as Alex Richard Soylak admitted his role in a stolen vehicle case while already serving a 12-month probation violation sentence. The hearing began with a plea agreement between the prosecution and the defense. Prosecutors agreed to reduce the original charge to attempted larceny, and in exchange, Soylak agreed to plead guilty. Before accepting that plea, the judge carefully explained every constitutional right he would be giving up, including his right to remain silent, his right to a jury trial, the right to confront witnesses, and the right to present evidence in his own defense. Soylak confirmed that he understood each of those rights and still wished to plead guilty. But before accepting the plea, the judge wanted to hear exactly what happened. He questioned Soylak directly about the incident involving a stolen vehicle outside a BP gas station. At first, Soylak explained that he voluntarily got into a vehicle that someone else had already stolen. The judge wasn't satisfied with that explanation and continued asking questions to determine whether Soylak knowingly participated in the crime. As the questioning continued, Soylak admitted that he knew the person who stole the vehicle and acknowledged that he got into the car to help that person carry out the theft. When the judge asked whether that statement was true or false, Soylak answered simply, "It's true." That admission removed any doubt about his involvement and established the factual basis for accepting the guilty plea. The judge then turned to another important issue. He asked whether Soylak was already on probation at the time of the offense. Soylak admitted that he was. The judge explained that by pleading guilty, he wasn't just resolving this new charge, he was also admitting to conduct that could revoke his existing probation and lead to additional incarceration. Even after hearing that warning, Soylak told the court he still wanted to plead guilty and confirmed that no one had forced him to make that decision. After accepting the plea, the judge reviewed Soylak's current legal situation. The court learned that he had already been in custody since June and was serving a 12-month sentence for a probation violation ordered by another judge. When asked about his situation, Soylak accepted responsibility, telling the court that he understood what he had done and that he was already serving his punishment. With sentencing approaching, the prosecution requested jail time. Rather than imposing another lengthy sentence, the judge decided on a different approach. Soylak was ordered to pay financial penalties totaling $575, with the alternative of 60 days in jail, but the judge ordered that any jail time would